Welcome to the session on Employment Exchanges Compulsory Notification of Vacancies Act 1959. This act, the purpose of the act is to provide for compulsory notification of vacancies to the respective employment exchanges. This is the purpose behind it, and the act is applicable for all the establishments where the people work for salary. That's all what it says. The Act is applicable to those establishments who employ more than 25 persons. Here there is no categorization. Everybody is included. The Act is applicable to all the establishments owned by central and state governments, including a local body. So it covers the whole gamut of private establishments and public establishments, central government establishments and even state government establishments. It applies to everybody. Here the employee means any person who is employed in the establishment to do any work for remuneration. As simple as that. It means that everybody is covered. Employer means any person who employs one or more persons to do any work in an establishment, and he is in charge of the supervision and management of the establishment. Establishment means, I told you already, it includes any office or any place where any industry, trade, business or occupation is carried out. Employment in public sector means a public sector owned by and controlled by the central government, the government or a department of the government, a government company, a corporation being a cooperative society managed or controlled by the government or even a local authority. A established private sector means an establishment is not in a public sector, but ordinary in the private sector, and ordinarily 25 persons more are employed to work for remuneration. Very simple. Now here there is only small classification been done as what they call unskilled office work. It means that for the people who are engaged in unskilled office work, in respectively these people, the vacancies need not be notified. That's all what it says. So the positions are daftari, jamedar, orderly or peon, dusting man or bundle or record lifter, process server, watchman, sweeper, or any employee doing any of the routine unskilled work with the central government notification, they will declare to be unskilled work. This is the only thing. When the Act is not applicable to certain vacancies. Any vacancy in employment agriculture, so this is not applicable. So agriculture is not a declared as an industry, so it is not applicable, including horticulture, so this is not applicable. So they need not have any kind of notification of vacancies. And employment in domestic service. If you employ anybody in domestic service, they are not included. Employment in which the duration is less than 3 months. If you employ people or supposed to employ more than 3 months, then the notification comes. If you employ people on temporary basis for 1 or 2 months or less than 3 months, this is not applicable. And employment unskilled work, to do unskilled work. Just now I told you what is unskilled work has been defined. So those vacancies of unskilled is not applicable. And any employment connected with staff of parliament, they are totally excluded. Anybody staff of parliament, they don't. And vacancies which are proposed to be filled through promotions or absorptions of surplus is not required to be intimated. For in the organization, what happens? Promotion vacancies may come because some officer may resign, vacancy may come. A person has to be looked into. At that time, promotion vacancies, if this act is not applicable, it is not necessary to be doing it. The notification vacancies. So every establishment is mandated that before you fill the vacancy, you need to inform the employment exchange in particular prescribed format, give all the particulars, and then give the notification through the notification to the employer, submit the notification. And there is no obligation here on the part of the employer to recruit only through employment exchanges. There is absolutely no law. It means that just because an intimation is sent to employment exchange, it does not mean that you need to recruit only through employment exchange. It is not there. The instance is totally different. So they totally barred from this kind of a thing. So here, of course, the one case, it came in Madras High Court. Mrs. Rajaram Krishna was the Director of Employment. He said the aim of running college is not to make profit. The object is charitable, since the advancement education is by NHRD. The activities of governing body do not constitute this occupation. College is not an establishment carrying an occupation so as to attract the projects of this act. So it says that education institutions do not fall under the category of this. In the definition establishment, it includes office is read along the definition established in public sector. It is clear that the government office are also included in the definition. It is very clear in case of Supreme Court also held in 1987 that even a government department is also an establishment under this act. So the act is applicable, they need to comply with the provisions of this law. And here also Madras High Court held that the word office is broad enough to indicate any place of business. So definition of establishment has taken into account considering the right of the legislative object. Club, despite the fact it is not a profit-making concern with a commercial motive, nonetheless an establishment under the Act. Even though the club says it is not a profit motive organization, but still for this purpose it is applicable. It is in the case of Consumer Club versus the District Employment Officer in 1975 Madras High Court decision. And in Supreme Court also very clearly it has said that there is no provision in the Act which obliges an employee to make appointment through employment exchanges. Because section 4 of 4 is very clear, explicitly make clear that your employer is not compelled to take only through employees. The Act does not oblige an employer to employ those persons who have been sponsored by the employment exchange. The Act is very clear. In fact, the Supreme Court also has reiterated this view very clearly in United India versus N. Hargopal case in 1987. So there is no obligation to employ only through employment exchange is up to his choice. And the section 5 mandates that periodical returns must be submitted to employment exchange as required. Number 1, quarterly return, the form prescribed, and biannual returns under the as per the format prescribed. So this is a little obligation on this employees on this. Plus, though the Act is very simple, and looking to the cases what I have quoted you, one should be very careful in complying with the process of law, because any time any contraventions can be questioned and the principal employer can be prosecuted for this. So number 1 is the notification of compulsory notification of vacancies before you fill up the vacancy, and second thing is submission of quarterly returns and submission of biannual returns. This is a must. Thank you.